Hi, Brianna here, and today I'll be covering the Second Amendment and its importance and challenges related to it. The Second Amendment reads as follows: a well regulated militia being necessary to the scrutiny of a free state, the right of the people to keep and bear arms shall not be infringed. In an article written by Robert Shalhoub, The Ideological Origins of the Second Amendment, he goes through many of these importance and origins of the Second Amendment. And the importance of this amendment is that it is vital to American liberties and emphasizes the individual's rights and privileges, and that the right to bear arms phrase makes up the essence of the amendment. The Second Amendment has been consistently interpreted throughout the Supreme Court since its inception. Opponents of gun control emphasize the individualistic character of the founders, whereas supporters of restrictive legislation keep insisting that these men were far more concerned with the collective behavior of Americans. The origins of the Second Amendment stem from the thoughts of Machiavelli. From him emerged the belief that arms and full array of civic rights were inseparable. To deny arms to some men while allowing them to others was an intolerable denial of freedom. This was the belief of Machiavelli, that arms were essential to liberty in order for the individual citizen to protect himself, to hunt, to defend his state against foreign invasion, to keep his rulers honest, and to maintain his republican character, provided an important foundation upon which subsequent Republican writers could build. Bearing arms was the primary means in which individuals affirmed their social power and political participation as responsible citizens. The themes associated with the right to bear arms was also shown in the Declaration of Independence and the Federalist Papers. However, there have been many challenges involving the Second Amendment throughout the years, and these challenges were in the form of court cases. In an article by Alan Rostron, The Continuing Battle Over the Second Amendment, he goes through many cases involving the Second Amendment. Judges have been looking at cases with more historical analysis of the Second Amendment issues. The minority view has arisen to challenge the general consensus in the lower courts, with a small number of judges rejecting the use of any sort of immediate scrutiny or other means-end analysis, and insisting that the basis of nothing other than constitutional text, history, and tradition. The first step requires a court to decide whether the case falls within the ambit of the Second Amendment. For example, in a court case, the District of Columbia versus Heller, they ruled that the Second Amendment does not extend to private activities like having a gun for protection of one's home and family against criminals. This became a complicated case because of the law in the District of Columbia. Within this complication, the Heller case was not put under such scrutiny because of the law that banned firearms for the protection of one's home. The court decided that this law was not obviously unconstitutional, so it was hard for them to come to a verdict. There were also other cases that were fairly easy to come to a conclusion based on the circumstances of the case. For example, United States versus Greeno, involving drug trafficking and the possession of a firearm. This person was clearly in the middle of a criminal act and was in possession of a firearm, and the Second Amendment did not give the right to carry out a criminal activity while in possession of a firearm. There were also other cases that were like this one where it was easy to come to a verdict based on the case circumstances, where criminals were in possession of a firearm, and the Second Amendment does not give that right to criminals. In another article by Adam Winkler, Scrutinizing the Second Amendment, an important question to ask is what standard of review would apply to laws burdening the right to bear arms if the court were to adopt the individual rights approach. No right is absolute, with the extent to which legislation can permissibly burden a right is largely determined by doctrinal rules, tests, and other devices the court adopts to implement the right. To conclude, the main question that judges are asking, which has sparked controversy, is whether the right to bear arms applies only to militias or to private individuals. This really has created most of the challenges and controversies among court cases today and in general. The Second Amendment gave citizens the right to bear arms, and even though courts over the years have been debating this issue among certain cases, the amendment is clearly states that we as citizens do have the right to bear arms, and not just to form militias, and that right cannot be infringed upon. Thank you.